From the Oregon State University Extension Service, this is Pollination, a podcast that tells the stories of researchers, land managers, and concerned citizens making bold strides to improve the health of pollinators. I'm your host, Dr. Adoni Melithopoulos, Assistant Professor in Pollinator Health in the Department of Horticulture.
The Endangered Species Act is almost 50 years old, and it has been a key piece of legislation for helping the recovery of threatened and endangered insect pollinator species. Here in Oregon, we have a number of bee species that are listed under the Endangered Species Act, and we also have, just last year, our first bee species, the bumblebee, Bombus franklini, Franklin's bumblebee down in southern Oregon. Now, the Endangered Species Act is a piece of legislation that I certainly wasn't familiar with, and so I was really excited to have our next guest run us through the kind of the various features of the act. Merissa Moeller is a natural environment and natural resources land use attorney at Stoll Reeves, a law firm out of Portland. She helps natural resource clients comply with environmental laws so that they can run their business and build healthier communities. She knows this. She knows the Endangered Species Act very well, and so in this episode, we go through the history of the Endangered Species Act, its intent, the various features associated with the act, and how it helps species recover. How a species is proposed for the Endangered Species Act. And some of the features, the kind of process from when a listing is petitioned for to when the actual legislation comes into place. I think this is a real timely episode, as there's potentially other bumblebee species that may be listed in the future in the Pacific Northwest.
So without further ado, Merissa Moeller this week on Pollination.
Welcome to Pollination.
Hi, thanks for having me.
It's great because over the past few months, I've got to get to know you along with a bunch of other really amazing natural resource professionals through the Real Oregon program.
Yes, that has been the highlight of my year so far. I am really looking forward to going to Ontario next month and getting to hang out a bit more.
Yeah, me too. It's been great meeting all of you. And we actually had somebody else from that group. Charlie came on and talked about removing bees in his spare time, removing bees from crawl spaces in Roseburg, which was wonderful.
That's great.
But here today, this is a topic that I've been really interested in. I know listeners have been really interested in. It's the Endangered Species Act. But before we get started, I think, you're a lawyer, you have a professional, you're a professional. You're not here in that capacity.
Yes, I have to give my standard lawyer caveat, which is I'm a lawyer, but I'm not your lawyer, listeners. So please don't take anything I say here as legal advice. And just for the record, not speaking on behalf of my employer or any clients, just as someone who works in this space and is very enthusiastic about the Endangered Species Act and natural resource management.
Fantastic. Thanks for the caveat. And I think, this is a large area. And if you are in a situation where you do need legal advice, you find legal advice for Endangered Species Act related issues. But we are coming up on the 50th anniversary of the Endangered Species Act. There was federal legislation to protect wild animals before the Endangered Species Act, like the Migratory Bird Conservation Act of 1929. What were the specific conservation problems that the Endangered Species Act was designed to solve, and what were the innovations of the act developed to address these problems?
Yes. Well, okay, that's a massive question. So I'll take it in a couple of parts. So in terms of the specific conservation problems that the ESA was designed to solve, I think it's helpful to take a step back and think about the time in which this law was adopted. So this was the time of a massive wave of environmental and natural resource legislation in the United States, the most significant that we've seen to that date and seen since. And this was during the late 60s through basically all of the 70s. And at a federal level, the government adopted, the Clean Water Act, the Clean Air Act, the National Environmental Policy Act, NEPA, the Superfund law, laws related to public land management, and many, many others. So there was just a lot of enthusiasm, I think, for environmental and natural resource regulation that hadn't maybe existed up until that point. In addition, the ESA was adopted, was about the bald eagle and other birds of prey.
Oh, right. I remember that. That was the bald eagles, the connection with DDT and Rachel Carson. There was this whole issue going on at the time.
Exactly. So this was about a decade after Rachel Carson published Silent Spring, and the public was concerned about DDT and its effect on basically thinning eggshells for birds of prey, and the ability of those species to basically procreate and persist. And in fact, the bald eagle and peregrine falcons are often cited as one of the major success stories of the Endangered Species Act. And so when Congress went ahead and adopted the ESA, that was really an issue that was top of mind. And it's wild to think now, but the ESA was passed by Congress almost unanimously. So the Senate passed it unanimously, and I think there were only 4 votes against it in the House, which is just a little bit bananas as someone who lives in 2021 or 2022 in the United States. Mm-hmm. And then I think another thing that's interesting to think about, so you can go ahead and read the congressional purpose statement of the law, which is, for all you legal nerds out there, at 16 USC section 1531. And among other things, Congress cites the, quote, economic growth and development untampered by adequate concern for conservation as a reason for adopting the law. So as you said, there are still, and there were before the ESA, earlier federal laws to protect wild animals, but the ESA is much, much broader in scope than those laws were. Traditionally, regulation of wildlife was left to states, and so the ESA is sort of inherently innovative in that it's massive federal legislation to address threats to protected wildlife and plant species. And I want to also mention and just highlight, the ESA covers plants, which is something that many people forget about.
Oh, yeah, of course. When you think about bald eagles, people don't think about endangered plants. And I guess this is coming up now because we've had our first listing of bee species. We've had butterfly listings for a while now, but invertebrates are also covered under the Act.
That's right. And so again, as you said, I think when the ESA was adopted, many people were thinking about these sort of iconic species like the bald eagle, or what we call charismatic megafauna, elephants and tigers and bears. And not top of mind were, the fish, the little tiny fish, or the invertebrates, as you said, that have become really significant parts of how the ESA is implemented.
Thank you. That was a really great, crisp overview. Let's get into it in a little bit more detail. I know enough to know that ESA has these 2 categories, and people probably heard them, threatened and endangered. What's the difference between them? And does listing under one of these categories make a difference when it comes to how recovery is instituted across a range of listed species?
Yes, great question. So there is a difference. There's a legal difference, and then there is a practical difference. And so the legal difference is that an endangered species is one that is in danger of extinction throughout all or a significant portion of its range.
Okay.
And a threatened species, which is a lower listing status, is one that is reasonably likely to become endangered in the foreseeable future. And so the difference there really is temporal. Is the species on the brink of extinction now, or is it headed that direction in the foreseeable future? And as a practical matter, the reason this matters is that the take prohibition, which I do want to talk about, does not automatically apply to threatened species. Mm-hmm. And so, although the service can choose to extend it. So under Section 9 of the ESA, which is one of the most impactful innovations of the ESA, and basically the reason it's such a powerful law, it's unlawful for any person to cause take of an endangered wildlife species. And as I said, this doesn't necessarily apply to threatened species, although in some cases it can.
Wait a sec. So I can imagine in the example of a bald eagle, somebody hunting bald eagle, but let's say it was accidentally done. You have a structure or windmill and it hits threatened. Is that a take?
It could be, and that's a great question.
Okay.
So take is sort of an old legal term that has historically been applied to wildlife, and it comes from the idea that wildlife is the property of the sovereign, at its oldest version, the king.
Oh.
And yeah.
Wow.
And so, but under the ESA, as you said, the term take includes direct actions like hunting or trapping or killing a protected species, but it also includes indirect actions that harass or harm wildlife. And importantly, the term harm has been interpreted by federal agency rule to include habitat modification that actually kills or injures animals by interfering with their essential behavioral patterns. So for example, if you want to build, to use your example, a windmill, maybe in an area where a listed bird goes to eat a specific type of grass, you could potentially be liable for take.
Okay.
The other thing that's important there about the take prohibition is that it's a strict liability prohibition. So strict liability means that intent and mental state are irrelevant. So under the take prohibition, it doesn't matter if you intend to cause harm to a protected animal, and it doesn't matter if you intend to cause the action that harms the animal. What matters is that you took the action that harmed the animal.
So if you had done something on a farm or something and you didn't have the intent of, perhaps degrading the environment for a threatened fish or something, that the law wouldn't look at that. It's not your intent. It's like that you actually, that this occurred. Am I getting this right? And I imagine when it comes to law, I can just see your legal face screwing up as like, this is a matter of, this is not so cut and dry.
Well, I would say that's true, but I think that's exactly right. That's sort of the general concept that it's extremely broad. And as a matter of civil liability, yes, your intent to cause the action that harms an animal is irrelevant. Okay, so let me get this straight. So when we look at, there are these two categories, endangered and threatened. And so threatened really is like something that maybe it's, as you mentioned, it's temporal. It's if things continue this way, it may become endangered. So you want to do something at this point to prevent that from happening. And endangered is where across the whole range where this species lives, it's reached levels which, if continued, it will go extinct. And I guess what you were saying is one of the driving differences is that there is that. This take provision is really exclusively focused on when something gets to the endangered category. Is that correct? So I would say the take prohibition does not automatically apply to threatened species. It always applies to endangered species. But one of the benefits of a lower listing, a threatened listing from the perspective of the federal wildlife agencies, as well as the regulated community, is that a threatened listing can potentially create some more flexibility around management. And so one of those pathways when a species is listed as threatened is that there is an opportunity for the service, Federal Wildlife Service, to issue what's called a 4D rule. And this is basically a special administrative rule that allows the agency to customize prohibitions and regulate activities that might affect the species. So one example might be when a forest species is listed as threatened, the service might conclude that certain types of logging activities can be operated within certain parameters that are designed to protect the species. And there's some additional flexibility around management.
Okay. So around this provision, if I can imagine if stakeholders get together and they say with the biologists and, this kind of practice really reduces incidental take or degradation of habitat. If you use these practices here that, and you can demonstrate using these practices that, gives you some standing if something happens down the road.
Yeah. So it's sort of a proactive opportunity to make some decisions about how to best, manage economic activity to protect species.
Okay. All right. Well, let's take a quick break. I want to sort of sit down and digest this. We're going to come back. I want to ask you about the actual process of how this goes. There's all sorts of, bees and butterflies that may have some issues with their populations. I want to walk through the steps of getting a listing.
Sounds good. Thanks.
Okay, so you talked about the broad law, these endangered and threatened species categories, and some of the provisions that are available to people managing on working lands. Did we cover everything, or is there more?
Well, there's always more, but I do have a couple of other provisions I think we should talk about. So you asked, what were the significant innovations of this law? And I think one of the most important beyond the Section 9 take prohibition is Section 7 of the Endangered Species Act. And so Section 7 creates an obligation for all federal agencies to avoid taking actions that are likely to jeopardize the continued existence of endangered or threatened species or result in the destruction or adverse modification of designated critical habitat. And so Section 7 is the way that the ESA really permeates basically every single federal decision. And that is how the Act really can federalize private actions that need federal decisions to authorize them. And so I'll give an example. So basically what Section 7 means is that anytime a federal agency is going to, is going to issue a permit or sign a lease or, issue some grant funding, the agency that's about to take that action is subject to this Section 7 consultation requirement. Oh. And so that agency has to basically, it's called consult with one of the federal wildlife agencies. There are two. The U.S. Fish and Wildlife Service manages terrestrial species and non-anadromous, meaning not going to the ocean, aquatic species. And then the National Marine Fisheries Service manages anadromous species like salmon, and marine species. And so Section 7 says that, if the U.S. Army Corps of Engineers is going to issue a permit to dredge a river, before issuing that permit, the Corps needs to consult with probably NIMFs and get that expert wildlife agency's take on the impacts of this proposed action on protected species. And the relevant, the Federal Wildlife Agency then has very significant discretion and latitude to impose conditions as a practical matter on the permitted activity to protect the species. So as I said, it's a way that the Act basically federalizes private actions and brings them under the ESA and can really affect what regulated entities and permittees can do.
All right. With that example, just to clarify, so I could understand if, a federal agency like U.S. Forest Service wants to log in an area that might be a habitat to an endangered species, they would have to go to U.S. Fish and Wildlife Service and say, if it's not an ocean going critter or plant, and say, what do you think of this? And they say, well, I think it's okay, or this may have some impacts. Does this only extend to federal agencies, or let's say you're a private timber company? Is this the same thing?
Well, right. And that's exactly the tricky nuance there. So it probably does apply to a private timber company to the extent that that company needs to get a permit from the U.S. Forest Service.
Aha. Gotcha.
So it's a way that the Act is a little bit sneaky in that it takes this federal agency obligation, but sort of transfers it onto regulated non-federal entities.
Okay, so this is one of the provisions. You said there's a few that we really should know about. What were some of the others?
Yes. Another one is Section 11, which is the section of the Endangered Species Act that authorizes citizen suits. So the idea here is that private citizens, in addition to the government, have a legal cause of action to enforce the law. And they can do this through federal court litigation, so long as they can demonstrate they've met certain legal requirements. And the citizen suit avenue is typical of other environmental laws of this era, although not all of them. But it's important because if you take this citizen suit provision and you couple it with Section 9, the take prohibition, you create a very potentially expansive framework for liability and risk of getting sued if you're an entity engaging in activities that may affect protected species. And so we've seen, and we'll talk about this maybe a bit more later, that litigation has a really important role in sort of driving policy decisions under the ESA.
Okay, so because the agencies may not have their eyes and ears everywhere, a private citizens group or private citizen can say, hey, listen, this is I noticed this is going on, and I think this is in contravention of the act.
Exactly. Yeah.
Okay. All right.
And then the last point I want to talk about, because I'm a lawyer for regulated entities, and this is a space I deal in, is that Section 10 of the ESA does create an avenue for regulated entities to basically get permits to authorize that they continue activities that may affect protected species. And so the result is called an incidental take permit, or ITP. And to get one, you basically have to prepare a habitat conservation plan, which is a proposal about how you're going to take certain conservation measures to minimize and mitigate your impacts on protected species. And then after an incredible amount of legal process, an administrative process, the service can issue an ITP. So this is sort of a pathway to insulate regulated entities from this very expansive risk of liability, but it's also a way to proactively develop conservation measures for the benefit of species in coordination with the Wildlife Service.
Okay, that's great, and I imagine this is when I've been introduced to this, my limited introduction to this, it's not like a one farmer. It'd be more like a group, people working in a region, the Northwest Forests or something. It would be something along. That's the kind of size of these things. Is that correct?
Yes, and there, I should say, there's a range in how big an HCP can be. It can be pretty limited, and it can be very, very expansive. But as you note, it's very, very resource intensive to develop one. Sometimes it can be, and so you do often see them on this sort of programmatic level to try to address similar activities across a large geographical area.
It seems like a great, I'll just, as an external observer looking inwards, it seems like a great provision because it allows an industry to get together with conservation scientists and really think through the steps where, their activity can continue without really threatening the recovery of the species, like thinking about what can we do different? Like what kind of steps can we implement that might make this, recovery possible at the same time as doing our work.
Totally agree. And I also think it's important to note that sometimes it's the only option to, continue on as an essential business. There are certain businesses and activities that we maybe don't think about as implicating the ESA. And for example, local governments are covered by the ESA. And, I work a lot with water utilities and entities that may have protected species in waters that they rely on. An HCP can be an option to basically continue delivering water and protect listed species that may be impacted by those operations.
Okay, great. Thanks. That was great. I think I'm sure there's more to this.
No. Perfect.
But okay, I want to get into this process of how listing takes place, and how does a listing get proposed? Like, where does that even come from? Because I hear this with bumblebees. There's been a number of proposed listings. I don't quite understand how they get started, how that ball gets rolling.
Great question. So there are basically two different paths. And this process is set for in Section 4 of the ESA. We're going to cover all the sections. It's not a very long law.
Okay.
And so basically there are two options. One, the Federal Wildlife Service can initiate a listing of its own accord. But they're very busy. And often what we see is that a listing gets initiated through the formal petition process. And so basically anybody can file a petition to the Federal Wildlife Agency and ask them to evaluate whether a listing is warranted for a particular species. And this is a public process. The listing process is a public process throughout. There are a lot of opportunities along the way to challenge the decisions that the federal agency has made. So there are a lot of opportunities to file lawsuits. And so frankly, we see a lot of litigation around this process. But once the service receives a petition, they have to evaluate the merits of that petition. And they go through a process. It's called a species status assessment. And basically, the service is taking stock of the species viability. And they do this based on the, quote, best available science. That's the legal term used in the Act. And best available science means just what it says. It means the science that is available. So the service is not necessarily under any obligation to go out and develop more science. They can if they want to. And then in response to the petition, the service ultimately has to make a finding about whether listing is either not warranted, warranted, or as a third alternative, warranted but precluded by a higher priority listing effort. And so that determination is subject to judicial review if someone files a lawsuit. And then moving on, if the service does determine that listing is warranted, the service will publish a proposed rule in the Federal Register, and it will explain its decision to list and its reasoning. There's an opportunity for public comment on what the service is proposing to do. And ultimately, the service has to respond to those public comments and publish a final rule deciding to list or not list. And then again, there's an opportunity for litigation.
Okay, so I guess there's checks and balances through the whole process. It starts with somebody it could be a NGO, or it could be, a local conservationist who's been watching a population. They assemble this petition, which has the evidence that the agency is to consider. Then I think I understood that the agency then needs to do this assessment, the species status assessment, or does it? Does it have to? Can it evaluate it on the first pass and say, well, Adonemelithopoulos actually doesn't know anything about frogs?
That is a good point. The service can basically knock out a petition at an earlier stage and determine there's not substantial information to move forward.
Okay.
But once the service gets past that point, the service is looking at information provided in the petition, but they also have to look at all other available science, the best available science. And so that's really where this broader scientific analysis starts.
Okay, because I imagine it's a tricky thing. There's not a perfect, way of assessing the viability of a plant or an animal species that is in itself comes with a lot of inherent uncertainty in terms of the prediction. And so I guess what are the steps that are taken to evaluate this data around a listing decision, and how does it, I imagine there's a lot of pressure on the agency to get it right, to really kind of, this is actually, how does that process of evaluation take place? So they must have to, like you say, they have to gather science that's been done. I guess they have to become like investigators of all the science of the species suddenly.
Well, I think that's right. There is, the service leads this process and they have to look at all best available science. And so they are working based on inherently uncertain data because there's no obligation to go, run every single piece of scientific information down to ground. And they do have to make policy judgment calls. And so this is often an iterative process. They are working with outside scientists. They're looking at all the published literature. Sometimes they are collecting more data. They're also working with other stakeholders who may ultimately be affected by a listing. But you're right. Ultimately, it is a policy judgment call. I will say, though, at the same time, there are legal sideboards on any decision that the service makes. And so the service can't make decisions that are arbitrary and capricious or not based on substantial evidence, which is the legal term basically for evidence that a reasonable person would rely on. Mm-hmm. And so when the service makes these policies decisions, ultimately, they're probably going to be reviewed by a court. Mm-hmm. And a court is then going to be evaluating whether the service had enough evidence to reasonably support its policy decision. And importantly, whether the service did a good enough job explaining its decision.
Okay. What are the timelines with this? So we've got a couple of steps. If I understood you correctly, it starts off with this petition. Petition, gets looked at, and then it gets worked up into this kind of accumulation of the best science with a species status assessment. And at that point, it then goes to this kind of rulemaking to sort of figure out what this is going to look like. What are the timelines associated with this whole? And then I guess, there's public comment, and then it gets turned into law, and this is the law of the land. How long does this all take, and Are there any kind of set timelines in the process?
Well, there are set timelines, but it can also take an extremely long time.
Okay.
So these timelines mostly come into play when the service is responding to a formal petition, as you said. And at that initial step where the service is doing an initial evaluation of the petition, they have 90 days to make a finding as to whether there's substantial information indicating that the petitioned action may be warranted. If the petition does clear that hurdle, within 1 year of receiving the petition, the service must make its determination that listing is either not warranted, or warranted but precluded. And then the service has to revisit its decision every 12 months after that. So it can be an ongoing process of evaluating a candidate species over a long period of time. If the service does publish a proposed rule to list, there will typically be a 60-day comment period. It could be longer. Mm-hmm. And then after the service publishes a final listing rule, there are legal deadlines to challenge the service's listing decision in federal court. And so we'll often see that, litigation is often a result of listing decisions, and those can drag on for years.
Okay. All right. So it can take a long time. And I guess maybe that's the other incentive to doing this right and doing your consultation up front is that if you run into all sorts of obstacles, the species may, a decision on what to do about it sort of sits in limbo for a long time.
Yes. And then I guess I will say, even if the service does everything right, they are still probably going to have to make it through legal challenges. And so, yes, just sort of best case scenario, there's a lot of time and a lot of process.
Well, I guess that brings me to my final question. I've heard a lot of discussion, whenever I'm in the hallways talking to either conservationists or people from industry that ESA needs an overhaul. From not your own opinion, but if you hear, which you're welcome to, but I imagine you've heard the arguments. So if you could briefly sketch out what are the arguments for people who want to see it changed, as well as arguments for actually this took a long time to come into place. It was bipartisan. It's solid. People who say it shouldn't change. It should remain the same. What kind of arguments do you encounter when you're out in the world?
Yeah. So, I think first it's important to recognize that industry versus conservation is not necessarily an accurate dichotomy. Mm-hmm. I think this is something that you run into with the work that you do. Mm-hmm. A lot of what I do is helping, the industry side of that framework, which isn't just, big bad corporations. It can also be state and local governments. But a lot of what I do is helping those folks comply with the Endangered Species Act, and it's so that they can carry on their operations for the benefit of our communities. And I find that for the most part, people acknowledge the value of conserving species, and there can be a lot of nuance. Mm-hmm. From the perspective of the conservation community, I think the major theme I hear is that the world is experiencing an unprecedented mass extinction. And there's a lot of concern about climate change and its impacts on species. And as you said, the Endangered Species Act is an incredibly robust law, and it's been around a long time. And I think there's a lot of interest in keeping it and in potentially strengthening it even further. Another concern I hear from that community is that the ESA's implementation can be very, very political. That's a concern I hear from other folks as well. Mm-hmm. And so there's often concern about who's in charge and who's directing federal agencies, because that will drive what listing decisions get made and, other decisions about how to interpret and implement the law. From the perspective of regulated communities, some of the major themes I hear, there are three that I can think of. So the first is sort of a cost-benefit analysis. The ESA does not explicitly allow for the consideration of economic impacts in listing decisions or in its implementation in many respects. And because it's such a broad law and so sort of such landmark legislation, it can be extremely expensive for regulated entities. It can also be extremely expensive for government agencies that have to implement it. And so I hear a lot of questions about whether the ESA is effective, how effective it's been in achieving its goals, and then kind of weighing those against the major costs of implementing it and complying with it.
Yeah, I imagine the way you would evaluate ESA and it's the effect, the ability for species to recover, that you actually, through this process, species come off their endangered or threatened, they've kind of recovered. And the second thing is that, people are able to do their business at the same time. That would be the ideal outcome of a listing, is that you see the species actually recover. It's not always not going downhill all the time. It came back. We did our job right.
Right. And that is the goal of the Act. And one of the, concerns people sometimes have is that that's often not the reality. There are many species that are on the Act and haven't come off. It's much more like common for a species to get listed than to get delisted. Another concern I hear, another theme I hear, is around process. So the ESA loves process, and a lot of it feels redundant. As one example, I talked about the incidental take permit avenue under Section 10. Well, shockingly enough, to get such a permit, the service also has to go through Section 7, which seems to be sort of a parallel requirement of the Act. And the service has to go through a number of other reviews under other environmental laws. And this is kind of the same process. Anytime you've got to get a federal permit, you've got Section 7 of the ESA, and then you've got NEPA, and then you've got the National Historic Preservation Act, and a bunch of other environmental reviews. So complying with ESA can be extremely time consuming. It can be extremely expensive, and these can be real challenges if you are on the site of needing a permit. And then the last theme I hear is around litigation. So as we talked about, the citizen suit provision is a major innovation in environmental laws of this era. And it's an important one. It also means that litigation ends up driving policy priorities often. And litigation can be very expensive and time consuming. So that's one concern. But I also think that there's some legitimate concerns about whether litigation is the best way to manage natural resources in every situation. And there are, competing views on that. But I think there's no disputing that litigation is expensive and time consuming.
Well, thanks so much for this. I feel way more educated. I know this is complicated, but this is a good primer for me and our listeners on Endangered Species Act. Let's take a quick break. We have this little segment that we do where we ask our guests some questions. We've never had a lawyer, an environmental lawyer. So I'm excited to see what an environmental lawyer answers. So we'll be back in just a second. Okay, we're back. So, book recommendation for our listeners.
All right. Well, I have two, and neither of them is an environmental lawyer-related book. So my first is a shameless plug a little bit. So my partner, Kyle Lascaretz, has an award-winning book out called Orders of Exclusion. I refer to this as the Mean Girls theory of international relations. And it's basically a theory of how global powers organize themselves to respond to rising threats. So that is timely.
Oh, wow. Certainly. We're recording this the day after the invasion in Ukraine. So this is, yeah.
Yeah, I hadn't even thought of that. That would have been my recommendation regardless. But for something a little lighter, I really enjoyed Cork Dork by Bianca Bosker, and that is about the science and culture of modern wine.
Really?
Loved it.
Oh, okay. So, I will get the titles. They'll be in the show notes. I imagine wine is this huge. We haven't had, I don't think, a wine person on the show, although there's all sorts of bee and wine stuff going on.
Ooh, I want to come to that taping if I can.
Great recommendations. How about your go-to tool?
Well, my go-to tool for working with bees is you, Andoni, because I think your passion for pollinators is infectious. I really enjoyed getting some bee coloring books, which I've shared with my extended family.
Oh, great.
And I also think you're a great communicator. I think you're genuinely interested in other people and learning about them and sharing information. So it has been a real delight to get to know you through Real Oregon.
Oh, thank you. Well, that's awesome. Well, thank you so much. That's really, really humbling. I don't know what to say. But that brings us to the last thing. So if I am your go-to person on on bees and pollinators, has anything sort of like popped into your mind as like, you just, whenever you see this critter go by, you're just so excited to see it?
Yeah, my pick is a hummingbird.
And they're all around right now. I
know. And I have a window next to my desk and I can see them when they fly by, which is always a nice bright spot of my day, even when it's snowing and cold.
I know. I have the same thing. I'm looking out my window and I've got a quince there and they're always covered with hummingbirds. So this time of year, I usually do the podcast from here at home. I've got a little home studio here. And so at this time of year, there's always a hummingbird kind of listening on the podcast as we're recording. So it's just a perfect choice. Anyways, I really want to thank you again on behalf of all our listeners for navigating us through the very complicated waters of the Endangered Species Act. I know you're a really busy person, and we really appreciate you taking the time to be with us today.
Well, thanks so much for having me. Hope you have a great rest of your day.
Thank you so much for listening. The show is produced by Quinn Sin and Neal, who's a student here at OSU in the New Media Communications program, and the show wouldn't even be possible without the support of the Oregon Legislature, the Foundation for Food and Agricultural Research, and Western SARE. Show notes with links mentioned on each episode are available on the website, which is at pollinationpodcast.oregonstate.edu. I also love hearing from you, and there's several ways to connect with me. The first one is you can visit the website and leave an episode-specific comment. You can suggest a future guest or topic, or ask a question that could be featured in a future episode. But you can do the same things on Twitter, Instagram, or Facebook by visiting the Oregon Bee Project. Thanks so much for listening, and see you next week.